Hello students, welcome back to Australian Government and Statutory Interpretation. Topic 11, Statutory Interpretation in Practice. This is the second of our lectures on Statutory Interpretation in Practice, where we're going to have a look at another case example. So these, last week we looked at the case of Lupino and Fisher, and we looked at some definitions in the Commonwealth Crimes Act. Remember, around the definition of a computer or a data storage device. Well, this week we're going to have a look at another case example closely, going through many of the same steps. So here on this slide is the list that you've been given in your textbook at 12.1, chapter 12. And this is a critical list. You'll want this with you in your exam because it's your sort of checklist of an approach, or the sort of latest approach to statutory interpretation. Not all things are going to be helpful, but it's a good procedure to go through. So we read it, we look at the jurisdiction, we find the active provisions and which sections you think might be helpful, and then look for any ambiguities or any technical meanings to deviate your interpretation from the ordinary and natural meaning. You then have a think about the purpose of the statute. You might also have a think about any legislative history, so explanatory memorandums or speeches, or have a look at the passage through Parliament. There might be law reform commission reports that generated the legislation in the first place. And then have a think about those statutory common law presumptions that may be applied, remembering though that they're easily rebutted with, well, not easily, with a clear and unambiguous intention of Parliament or clear words. So I'm going to take a slightly different approach today. Last thing we looked at was Lupino and Fisher, and we started off with the judgment. I'm going to take a different approach, but the main point to note is how the court approaches this task of statutory interpretation. Does it consider the words in their context straight away? Does it turn to extrinsic material? And whether it takes any presumptions into account, for example. So this week's case is called Uber BV against the, or and, never say versus in law, just and, Uber BV and the Federal Commissioner of Taxation. And you'll see a number of cases in the federal jurisdiction where the Federal Commissioner of Taxation is a party, and that is because, as you can imagine, it's usually disputes against ATO rulings, and then the Commissioner, who's the delegated executive member who exercises the power under the Act. In the regulations, they appoint a Commissioner usually, and then they can exercise the powers. They're obviously usually the litigant. Okay, so here's an interesting point that the court had to answer, and that was whether an UberX, or indeed any regular Uber driver, is providing taxi travel, in air quotes, for the purposes of a new tax system, brackets goods and services tax, close brackets Act 1999 Commonwealth, which is much more commonly known as the GST Act. And why would that matter? Well, if an Uber partner is providing taxi travel for the purposes of this GST Act, then they have to register as a business for the purpose of GST and lodge business activity statements, that's BAS statements, and all those sorts of things that most businesses with a turnover of more than $75,000 a year threshold, if you have a turnover more than that, everyone else in the rest of Australia has to register for GST. Now, although many Uber drivers might not necessarily meet the $75,000 a year threshold, taxi travel, those two words, is a specific exemption in the GST Act, and all those providing taxi travel would have to register for GST, and we'll see the reasons for that a bit later on. Just why Uber BV is a good question. Well, BV is the Dutch equivalent of PTY or LTD that you see on lots of other companies and lots of other parties' names in litigation. And Uber BV is a subsidiary of Uber International Holdings and the Uber Technologies Company, which you'd be more familiar with. They're California-based head offices. So there's subsidiaries, all of them are subsidiaries, as I understand, of Uber International Holdings. It's the way they've been set up, and it's the way Uber have set up their international operations. And I've got a link here to an article by Business Insider who looked into Uber BV, which is the Dutch, and it had 0 full-time employees listed. So they raised that, and the company responded to Business Insider that it's shifted things around a bit and has actually got quite a few employees, more than 0 running Uber. But the journalists were skeptical about that claim, and it appears that the company has been organised in this way for tax purposes, as many multinationals are, and you'll be familiar with the news and big international corporations in the news not paying much tax in many jurisdictions, which is a big problem, isn't it, for society, as we channel our money into these big conglomerates and then they avoid paying any tax. All right, so in this case, arguing about the applicability of GST, goods and services tax, I'd like to first look at the arguments of each party, and then we'll come to the court's decision. All right, so a little bit different from last week, where we did the decisions of the courts first, and in the court of the first instance, remember, the Magistrate Fisher, and then the single court justice, Federal Court Justice, Justice White. So instead, we're going to look at the grounds argued by the parties first. So what did Uber and the Uber ex-partner, Mr. Fine, whose liability for GST was in question, that was Mr. Fine, what did they argue before the federal court? Well, they said the context of the definition of the words taxi travel in the Act indicate that it was intended to regulate a specific industry. All right, so they've gone for the words taxi travel, but immediately jumped on an argument of context. So it's specifically targeted at the taxi industry to make sure that it all paid GST. Taking taxis, said Uber, to mean any vehicle for hire for a fee by members of the public would be to define that too broadly. All right. And they went on to say that taxis have got a particular, or do have particular defining features, marking them out from Ubers, such as physical markings, certain color schemes and that checker motif down the side, identifying them as taxis, signs on the roof, lit up, boot lights to indicate whether they're carrying a fare, uniforms of drivers, etc. They're generally prohibited from refusing any customer. That's the cab rank rule, isn't it? Where they have to just take whoever's at the front of the queue. They're allowed to use taxi ranks, including at airports, which Ubers are usually not. They can pick up hails at the curbside. You can hail down a cab, taxi, which is not how Uber works at all. It's all prepaid and booked through the app. They can drive in bus lanes and transit lanes with any other number of passengers, or indeed no passengers at all. And, said Uber, they've also got an official taxi meter which displays the fare progressively throughout the trip. And they said all of these things mark taxis out as being distinct from Ubers. So just pause there. What do you think? Do you think an Uber is a taxi? Do you think it should be a taxi travel for this purposes of this act? So this is one argument put forward by Uber. All right. So how did the Federal Commissioner of Taxation respond? Well, obviously they want to capture Uber in the definition of taxi travel, don't they? Because then they suck them up into that definition and they all have to register for GST, and you're much more likely to collect GST, aren't you, if you've got them mandatory reporting. Puts all obligations on them, reduces chance of fraud. It's one thing not declaring, it's another thing declaring incorrectly. So you can see in the Federal Court's judgment that the Commissioner contended the definition of taxi travel is to be construed as a whole. It connotes the transportation by a person driving a private vehicle of a passenger from one point to another at the passenger's direction and for a fare. So you're moving a person from A to B for money, and that's irrespective of whether the fare is calculated by reference to a taxi meter or prepaid or whatever, you know. And, you know, some of those taxis now prepaid before 10 p.m., you know. So that's not uncommon, is it? Sorry, after 10 p.m., you know, between the hours of 10 and 5 in the morning, they're not risking trying to get payment after the service has been delivered and the punter has been taken to their destination. They're not risking that, probably because of alcohol prevalence after 10 p.m. till 5 a.m. So they want prepaid fares. So that's not a big news, is it, in taxis anymore? All right, so the tax commissioner is essentially arguing that what Uber does is close enough to taxi travel. It's got salient features that may not have all the features of the taxi travel with the checker flag and the little light, but it should still come within the definition. The tax commissioner added that the state and territory taxi regimes, which Uber referred to extensively, they called an expert witness who's an economist who looked into state and taxi regulation, you know, extrinsic materials to try and shed light on this specific statutory provision. And we'll come to that in a minute. But the commissioner said, look, you look at all these special legislative regimes to regulate taxis, that's all irrelevant because the GST Act is a federal law. So we don't really care what the states and territories are up to with their definitions in their local or state legislation. And the federal court said, the commissioner said the federal court should not concern itself with what state and territory laws say about taxis. Which, you know, it's an interesting argument, isn't it? That, hey, this is a federal legislation. Why are you talking about what the states and territories legislation uses the word taxis for? All right, so quite divergent arguments, right? And you've got to reconcile them, haven't you? This needs a judgment. There's a dispute before the court, and the court needs to resolve that dispute. So we've got to take Justice Griffiths, or Justice Griffiths of the New South Wales Registry at the Federal Court, attempting to undertake this task. And his judgment, there's a link there, is of the 17th of Feb 2017. Now, Justice Griffiths points out that section 144.5, subsection 1, requires GST registration for those who supply taxi travel, regardless of turnover. So that's the starting point, and that's the point of that provision. So that's the threshold for any other businesses. It doesn't matter if they make $75,000 or more, but if they're doing taxi travel or they're engaged in that, then they must register for GST. So in that case, Justice Griffiths said, we need to look and see if there's a definition of taxi travel in the Act. So where does he turn? Okay, so Part 6.3 of the Act, labelled Dictionary as a heading, and specifically Division 195, Dictionary, contains 3 schedules, sort of listing all sorts of things that, or food and goods that are not GST free, beverages, medical aids, and appliances are exempt from GST, but Section 195, subsection 1, or point 1, sorry, has some of these definitions that we might be interested in. In particular, taxi travel's in there, and it says means travel that involves transporting passengers by taxi or limousine for fares. Now, there's no definition of taxi or taxi operator or limousine, and here's a classic quote from Justice Griffiths that says, the core issue of construction is able to be expressed in relatively simple terms, but perhaps not unusually, the resolution of that issue is more complicated. And probably a phenomenon that's becoming increasingly familiar to you as we study the statutory interpretation cases. I mean, they can go either way, can't they? It depends on, well, how well it's argued before the court, and then the logic of the judge, and whether that can withstand an appeal to more judges, if it's indeed successfully appealed up the court hierarchy. So it seems quite straightforward, but actually it's a bit tricky. All right, so it might seem simple. Justice Griffiths is saying it just concerns what most people would take to be fairly simple words or phrases, but then often the complexity is brought to bear when you start considering the context of the words in the provision in the Act, and then parliamentary intentions. All right, so to help us illuminate that, I want to dive into both sides of these arguments in a bit more detail, because ultimately they're the arguments on which Justice Griffiths has to rule one way or the other. So by attacking it from this angle of unpacking the arguments of counsel from both parties, you can understand how then Justice Griffiths reconciles those and reaches a decision. So I haven't set them out fully, not every aspect of every argument of both parties, but in my opinion, some of the more salient features or highlights of the arguments. So Uber's first argument with respect to construction, and remember construction is just another word for interpretation, which is how words and phrases are construed. So is taxi travel, that taxi travel denotes a particular industry in the GST Act. It denotes it, it defines it, it articulates, it puts some boundaries around it. It did not connote anything that looks like taxi travel to extend to some new state of affairs. All right. So if you look back to the Lapino case last week, week 10, you remember where the judge said we need to look at the ambulatory meaning of the word computer. All right. And so the full federal court on appeal found that the word computer was broad enough when taken in an ambulatory or dynamic context to encompass a mobile phone, data storage device. Take a photo. Where's the photo? Stored on the phone as data. All right. So this is a similar argument. Uber lawyers are saying, hang on, taxi travel denotes, so it refers to taxis specifically as an industry. They don't connote That is also referred to associated things, anything that looks like taxi travel. So they're saying it should be construed according to its ordinary meaning and not some meaning that has evolved over time to encompass alternatives to taxis, ride-sharing services. Right. The second argument is that the words taxi and limousine should be used in their trade or non-technical sense because the legislature intended to carve out a specific industry, the taxi industry, from the operation of an otherwise universally applicable rule that you only have to register if you get the 75k threshold. All right. So, okay, so we will clear that the second argument they were saying you've got this recognizable industry, and in the trade sense, taxi, limousine, Uber's not part of that. Okay, the third argument they said is by using the words taxi or limousine, Parliament must have intended different things by those terms. This is really good, right? Because do you remember Project Blue Sky? The lawyers for Uber remind Justice Griffiths, the High Court was told Justice Griffiths and the lawyers and everybody that courts must attempt to give effect to all of the words of a statute, and you can't assume that a word is redundant. So what's the point of saying taxi or limousine if taxi was broad enough to then encompass limousine, Uber, anything else, right? So they're saying, but by adding limousine, there's taxis, there's limousines, and then they'll say, well, so therefore, not by implication, not Ubers, right? They're different things. Otherwise, they wouldn't have carved it out. So they've called an expert witness, as we mentioned before, Dr. Peter Abelson. He's an economic consultant. He's an academic and happy to take some money to do and be an expert witness in court cases, to tell the court taxi's got specific meanings. Let's have a look in state and territory regulation around Australia. And in general usage, no one calls an Uber a taxi. Indeed, the whole point of having Ubers is not taking a taxi, they argued. What do you think? So Uber's fourth argument, it urged Justice Griffiths to be cautious before attributing to the legislature an intention to include within words of settled meaning at the time of enactment later technological developments unforeseen at the time of the enactment. Well, so sometimes there are gaps in legislation, and we've got social change over time, and we saw that with the Lupino case, didn't we? So the courts can sometimes fill these gaps by reading in or interpreting the legislation in situations that were unforeseen by the drafters. Sometimes there are drafting errors where the legislature, according to the courts, should have foreseen certain situations, failed to do so, and then sometimes courts need to supply their omission. So Uber's saying, hey, the court should be cautious in applying any of those doctrines of interpretation here, because this is not just a situation of a taxi service evolving, they argue. Their ride-sharing technology is quite different. It's a distinct service. All right? It's not the old-fashioned taxi, fixed, meter-based, just moving around, you get in them and you pay for what you use and you get out of them. This is totally different. This is ride share, this is whoosh, this is technology, this is prepaid, this is see it on an app coming, it's my cab, I've booked it. Oh, I said my cab, didn't I? Whoops, see? Oh, it's close, isn't it? It's my Uber, I booked it. Okay, they make a fifth argument that the New South Wales and the ACT laws, which regulate Uber specifically and directly in those states, they clearly confirm a distinction between Uber services and taxi services. Otherwise, they wouldn't have bespoke legislation, would they? And then a sixth argument in those jurisdictions. And then a sixth argument is that UberX service, which is the sort of cheapest services, are completely different, not only from taxi services, but from limousine services. And I think here they're trying to use the, this is the cheap and cheerful budget version and juxtaposing that with limousine, right? It's the almost the exact opposite of a limo is a Toyota Corolla, isn't it? Or a Yaris. It's a small, cheap car. So they said that's, limousines, luxury, sometimes large stretch limo. This is a Yaris. Okay. All right, we'll take a break there, and then when we come back, we'll have a look at, the Empire Strikes Back, the tax commissioner. How are they going to bat back these six arguments? We've already foreshadowed one about the ACT in New South Wales and the federal Commonwealth Commissioner saying, I don't care what they do in those two jurisdictions. I'm a Commonwealth legislation. So it's irrelevant. All right, we'll come back in a moment. Thanks.